morning. How are you today? It's a couple minutes before we start here. You're tuning into myself doing a play-by-play on Tamara Lich's bail hearing. It is not legal for us to broadcast the information, so I'll be doing just my take on the proceedings as they go forth. I'm currently looking at a courtroom that has 4 people in the first row, about 8 people in total in the court. There is looks like the lawyer's up front. The judge is coming in right now. Judge comes in with a red sash, bows to the court, puts his paperwork down. All the things that you do in a court. Tamara has just been led into the box. She does not have shackles on the feet, but she is in handcuffs, and she's got a sweater over her hands to cover the cuffs. By the way, folks, if you're sharing this out, I encourage you to do so, but please put a title when you share it. Don't just share it. Share it with a title so that people will know what it is that they're watching. It will also help us with the traction. The more you share, the more you comment, the more you like, the more it helps other people to see this information, which is really important because there's a media blackout. So they just went through the preamble about how you're not allowed to record. Thanks for joining me. And counsel, you will be receiving full width and reasons for this matter, but not today due to time. This is the judge speaking. It was a challenge, and before those written reasons, in due course, in any event, I'm going to provide you with my oral reasons, and I reserve the right to clarify those reasons, and will if necessary. In the matter of Regina and Tamara Lich, an application pursuant to Section 520, the Criminal Code of Canada, in review of the applicant's Tamara Lich detention order. Ms. Lich was detained following a bail hearing July 8th, 2022 before Justice of the Peace Harris of the Ontario Court of Justice in Ottawa. The applicant stands charged with 1 count of counseling intimidation, a count of resistance of a peace officer, a count of resisting and willfully, a count of intimidation, and count of mischief, a count of did not comply with a release order. The alleged dates for these offenses between February and June 2022. The Crown will be proceeding by indictment. The predicate offenses arise out of the so-called Freedom Convoy that occupied the downtown core of Ottawa for an extended period of time earlier this year. It's alleged that Mrs. Lich was the organizer of the highly disruptive event that occurred at or near Parliament Hill. The most recent charge stems from the applicant's actions at an awards gala held June 16, 2022. On July 8, 2022, the Justice of the Peace ordered the application's detention on the second and tertiary grounds. Ms. Lich has remained in custody since her arrest June 22nd, or 20. This is the 3rd success bail review application in the Superior Court. The positions of the parties. The applicant argues that there was an error in the bail review. The applicant submits that the detention orders are completely inappropriate based on the fact that the Ms. Lich, 49-year-old grandmother with no criminal record, who identifies as Métis, with a stable employment history, and an available surety that was previously approved by 2 judges, and is deemed to be qualified to act by the Justice of the Peace. Substantive offenses are nonviolent in nature, and a new breach allegation raises strong trouble issues. it endangers the protection or safety of the public. The applicant submits that the decision here bears a striking resemblance to the thing that happened on February by the evidence Justice Bourgeois, Justice of the Peace, made one of the key errors as explained by setting aside the detention order by Justice Peace Harris. Is looking at the potentiality of a long prison sentence on the tertiary grounds. Specifically, the applicant argued that the Justice of the Peace did an error in law in assessing the apparent strength of the case, that failing to consider any of the changes of circumstances since the applicant's original arrest, as has been identified by Justice Phillips' review as of May 25, 2022. Further, the application alleges that the Justice of the Peace did an error of law of the fundamental principles of the targeted risk of the secondary ground, which is the applicant also submit that the decision was clearly inappropriate and replete with statements of fact which were not supported by the evidence of fact and devoid of proper logic and analysis. The applicant requests that the detentor be set aside and be replaced by a release order with essentially the same terms as the same ruling of May 25, with some consideration to address the non-communication going forward so that there's not another hearing for a sixth time dealing with judicial interim release in this matter. The Crown responds that the Justice did not commit an error and did fully commit her flagrant breach of the proposed plan. Justice of the Peace considered the thing fully and fairly and arrived at a reasonable conclusion. The Crown contends that the allegation involves serious misconduct. The Crown says that the strength of its case with Ms. Lich's conduct while on a former form of release, resulting in a wanton disregard of abiding by the bail conditions, has not changed the very real concerns of her inability to follow orders. The Crown asserts that none of the facts asserted by the defendant with respect to the tertiary ground, the Crown refers to the evidence to the effect that the prosecution's case is very strong and the applicant faces the potential of a lengthy sentence. The circumstances surrounding the commission of the offense are most serious and have and continue to have critical consequences that go beyond the nature of the charges. Further, the Crown reiterates that Mrs. Lich was flagrantly flaunting the conditions of her release and demonstrated a fundamental lack of interest in following the court order. The Crown submits that the public will lose confidence in the administration of justice if the applicant was permitted again to be released on bail under these circumstances. The Crown submits that the application ought to be dismissed with the applicant's continued detention until trial. Counsel, for the next several pages, I have a summary of evidence as provided by the applicant in her factum that I included. I'm not going to read it now. I'll read it when you receive my fully written reason. Legal principles. It is well settled that the approach to bail review under Section 520 or 521 of the Criminal Code has been revamped since the release of the Supreme Court of Canada seminal decision in Regina versus St. Cloud In St. Cloud, in paragraphs 120, 121, the Supreme Court explained, and under Section 520 of the Code, the reviewing judge does not have an open-ended power to review the initial order with respect to detention or release of an accused. It will be appropriate for the reviewing judge to review if the justices have erred in law, if the decision was clearly inappropriate, that is, if the justice gave excessive weight to one or insufficient to another facts of justice, or 3, new evidence is tendered that is material to the circumstances of the case. In accordance with the secondary ground, detention is justified or necessary for the safety of the public in regard to all the circumstances. It has been settled that in dealing with the secondary ground, the danger or likelihood that an individual will commit a criminal offense is not in itself provide just cause for detention. Appellate courts upheld that in general, society does not count preventative detention of individuals simply because they have a proclivity to commit a crime. He's referencing Morales, which is on page 32, which is a case law. The authorities provide that the fundamental, that the judge can see that it's justified in this specific case. They're repeating that if bail is not denied, that then all people who are committed by offense or could incur upon justice, bail is only denied for those who prove to be a substantial risk to the administration of justice. The Supreme Court of Canada provides fresh insights regarding the tertiary grounds. The applications in these grounds is not limited to these circumstances, unexplainable crimes, or to certain classes of crimes. There is no requirement that this provision is to be interpreted narrowly or sparingly applied. To answer this question, the court must adopt the question of a reasonable person who is properly informed of the provision and the actual circumstance of the case. However, this person is not a person versed in law or the various defenses that are available. In mention, the application of, it's not limited to exceptional circumstances or an unexplainable crime. The Crown can rely on this for any type of crime. The question is that whether the detention or release of the accused is required to maintain confidence in the administration of justice. As mentioned, public heat consists of someone who is thoughtful and not prone to emotional reaction. This person has the right unless just cause is shown for the detention. A reasonable person in the justice system is undermined also if it orders detention where detention is not justified. Also point out that public hearing about public safety, although relevant, are not the exclusive consideration in assessing the public's confidence in the administration of justice. See St. Cloud, paragraph 73. The 4 circumstances outlined in section blah, 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 detention is justified or necessary to maintain public confidence in the administration of justice in regards to all the circumstances, including the apparent strength of the prosecution case, the gravity of the offense, circumstances regarding the conditions of the offense, including whether or not a firearm was used, and the fact that the accused is liable on conviction of a potentially lengthy term of imprisonment, or in the case that involves the subject matter, that the minimum punishment would be 3 years. The aforementioned circumstances listed in the criminal code are not exhaustive. The court must not pay attention even in a situation where the circumstances support this result. Rather, the court must instead consider the totality of the circumstances and pay particular attention to the mitigating factors to determine whether or not the detention is justified. It is also considered that the jurors must consider the... Sorry guys, I'm doing my best. I now turn to the application of legal principles in this case. My role or function in this bail review is not just a matter of substituting my opinion for that of show cause justice, for that is not permitted. In Regina versus Morris in 1995, in the Court of Appeal, Justice whatever explained what the phrase misapprehension of the evidence means in paragraph 83 of that decision. Quote, a misapprehension of the evidence may revert to a evidence relevant to material issue, a mistake as to the substance of evidence, or a failure to give proper effect to the evidence, end quote. The courts are required have to deal with the live issues of the case and have to be have been fully discussed by Judge Chiron. And he's making more reference to other materials. He's not going to read it, thank God. Continuing. Of course, we are dealing with reasons provided by a justice of the peace at a show cause hearing. For the most part, this branch of the Ontario Court of Justice, comprising of justices of the peace, is a lay bench.
Is this the judge speaking?
While this was not a typical show cause hearing, I am mindful of the busy bail courts in Ottawa and the time constraints placed upon judicial officers. To address the reality of that, Justice Hill in Regina versus Brooks 2001, 153 whatever, and I'll quote, while the judicial presiding in a busy court providing reasons for detention in that case need not deliver breathless prose or slavishly track the wording of one paragraph, the text of which must, in a coherent fashion, lay out the grounds set out in section 15, end quote. The separate case instructs the court to take a functional approach. The inquiry should not be conducted in the abstract, should be directed as to whether a reasonable response in cases at issue in regards to the evidence as a whole and the submissions of counsel. See also Regina DJJR 215 CC paragraph 32. I do not wish to overemphasize it is expected that a justice of the peace conclusions or justification for the detention of an individual will be reflected in the reasons. Indeed, this decision is not to be taken as to be setting any threshold or the delivery of reasons. Again, the judicial officer did not discuss every piece of testimony that came before him or her, nor is it necessary to reflect upon the account or recite all the evidence. However, there has to be the analysis of the evidence to support the conclusions. Cogent and reasonable analysis of the evidence that is not only necessary for the potential review, but serve the interests of the parties and the administration of justice. I then quote for the law of Carswell, pages 5 dash blah, 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 regarding the relevance. And I will not read that into the record. You can review that in my written answer. Continuing. This trite law, section 518, subsection whatever of the criminal code, also confers broad discretionary powers on the justice conducting a bail review. For example, the justice may make inquiries, take into consideration any relevant matters given by counsel, and receive as basis of a decision on credible and trustworthy circumstances of each case. Some of these provisions in section 518 pertain to relevance, while others deal with admissibility. Collectively, subsections give broad discretion as to what kind of evidence may be deduced by the parties. Turning now to alleged errors based on the record. Justice of the Peace Harris gave 29 pages of transcript. The apparent strength of the Crown's case. The applicant contends that the Justice of the Peace, when examining the... Oh, God, sorry guys, I'm trying. Stipulates exceptions that include, quote, in the presence of counsel. During the court's submission, the Justice of the Peace inquired of the events, quote, do you have any testimony from any lawyer to say that we're at the table or they were in the vicinity at the time of the photo? Talking about the lawyers. When the attentions was drawn to the sureties... Ooh, we just got booted. Nope, we're back. This is a bail hearing. We're talking about matters that relate to Mrs. Lich's potential for bail. We're not talking about the trial down the road. So I need a reverse onus. It's up to Ms. Lich to show the court to support her statement that, as you've stated, there were lawyers present. End quote. To determine there was no viable evidence tendered to confirm the presence of legal counsel. While there was a reverse onus at the bail hearing to justify release, any assessment of the apparent strength of the Crown's case is necessarily an assessment of the relevant strength of the prosecution's case at trial. With respect, I must disagree with Mr. Karimji's decision regarding the burden of evidential proof imposed on an accused and a suggested inferences to draw on Morales and other case law. A show cause hearing, there's no onus on the application to negate the strength of the Crown's case or, as stated by the Justice of the Peace, to support her statement. As the Supreme Court of Canada noted in St. Clair, the justice of the bail hearing must also consider the offense, the defense. But if there appears to be some basis for the event, the justice must take this into account when assessing the apparent strength of the Crown's case. As the Supreme Court observed, it would be unfair to allow the prosecution to state its case if the justice is not in a position to consider not only the weaknesses of that case, but also the defense it suggests. The police investigation did not identify everyone in the alleged offense, nor conclusively identified applicants at the defendant's table. There was suggestions that there was lots of lawyers from the Justice Center whom she did know who they were, that were situated there at the time. The surety had attributed a statement of the applicant to the effect, reciprocally invoking a claim to the counsel on burden, while the souls, it was hearsay, which was admissible at bail hearing. The circumstantial evidence suggests that such a statement could be used at trial. The evidence garnered by the police is not entirely inconsistent with the applicant's claim that applicant's surety and subjectively believed that she did not circumvent her conditions. In questions from the surety, owing to his erroneous belief of a reverse onus hearing and further support of her statement invoking the defense. Without descending into the abyss of speculation, there was an error of reality that legal counsel might have been in close proximity or at least present during this engagement in which contact and communication with Miss. The legal error sustained the notion was under evidentiary notice to provide evidence of the strengths of the Crown's case. Turning next to the interpretation of the release order condition of the applicant. I agree with the applicant that the Justice of the Peace compounded this aforementioned error by misapprehending the evidence and not providing the necessary legal standards applicable to qualify for a breach in a criminal trial. This is most aptly illustrated through the Justice of Peace quote, "It is absolutely ridiculous to think that the intention of the court-ordered condition not to communicate and have no contact be superseded simply by the lawyer's presence." He takes a drink. As mentioned, the specific conditions excluded contact. The release condition was without qualification or limitation by nothing further of the applicant. Whether or not its spirit or intent was, as described by the Justice of the Peace, except where in the process of the to the charge basis, is not sustainable, considering the broad language with respect to the interpretation of the clause, where there may be ambiguity in accordance with statutory interpretation principle. The strict wording of the release condition must be adopted. While not on all fours, by analogy, this principle refers to Regina versus Legier in the Court of Appeal, Regina versus SAC 2008. Nonetheless, this approach is consistent with the principles of fairness that is at stake. Any provision advanced as a basis to limit the liberty of the accused must be strictly construed against the state, rather than expressing that the defense position be absolutely ridiculous. That any communication in presence of the counsel would be a full defense of the charge. Thus, properly considered, the claim that counsel was present was not absolutely ridiculous or the kind of excuse that was characterized by the Justice of the Peace. Moreover, my reading of the transcripts tend to suggest that the Justice of the Peace may have proceeded to deem the arguments by the defense counsel, even if the Justice of the Peace was correct, that the subject condition interpreted according to the original failed to consider that would almost inevitably and necessarily cause a mens rea problem. A law under the breach under Section 145 was subjective knowledge, recklessness. I am not persuaded that the case of Regina versus McCaffrey, 2020, OJ number whatever, to assist the Crown. It speaks only to the issue of the legal scope or effect of the condition and a mistake of law, and not to the specific issues raised here. In order to convict on a breach, the accused must know what the condition is that they're subject to at the time of that it was alleged to be a breach. In this case, the applicant would have needed to know that, subject to the condition would have been different than as worded on the release order. The Crown would be required to establish that the applicant knew or was reckless to the fact that she was subject to a more preventative or restrictive condition than what the condition itself said on the face of the order. In this case, the plain language reading of the condition, that contact and condition of no contact with people, including Tom Marazzo, as long as it took place in the presence of counsel. The police were aware that Mrs. Lich would attend the event sponsored. In my view, the justice overemphasized its scope. Next. This is looking good. While the justice of the peace properly identified a number of circumstances to consider in relation to the secondary and tertiary grounds, it appears he did not conduct an analysis of many of the relevant circumstances that had changed since the application's initial arrest. Justice Phillips identified a number of changes since that time that, in his view, had they been known to Justice whatever, would have led her to a different conclusion. It seems to me that had these circumstances been considered by the Justice of the Peace, it would have resulted in a different conclusion. These findings include that the Freedom Convoy was over and had left town. It would be practically impossible to mount a comparable protest. The applicant has stayed off of social media since her release. The circumstances of the pandemic and the government's approach has changed. He also stated circumstance relevant to the bail process in the sense of the likelihood of a further criminal offense and the assessment of what it would take to maintain confidence in the administration of justice is materially different now than it was back in whenever, end quote. It's looking good, folks. The Justice of the Peace ought to have noted Justice Phillips' approach of saying that there's a risk of repeat behavior that led to the charges in the first place. To the contrary, rather than focus on any presence by the applicant herself as a result of a breach on a Section 524 analysis, the Justice of the Peace made the bold assertion that the applicant continues to pose a risk to the public, knowing, quote, that the protests continue here in the nation's capital and in other cities of Canada, end quote. Now relating in particular by her release. Clearly, with the fresh evidence produced by the Crown, this conclusion was not linked to the current circumstances that brought the application back to the show cause hearing. The Justice of the Peace apparent focus on item number 17 did not change that reality. I will speak more about this momentarily. Let me now address the secondary. As mentioned earlier in Morales, made clear that the danger or likelihood of reoffense does not provide just cause for detention or would justify in detention in secondary grounds, not just the applicant would reoffend, but reoffend in a manner that would hurt the danger of the public. Okay, so the Justice of the Peace didn't address this important distinction. Given that the applicant doesn't have a criminal record and is charged with totally nonviolent offenses, a new allegation of breach is not necessary for the protection and safety of the public. Rather than addressing the alleged thing as vagrant, the Justice of the Peace need to grapple with the circumstances of the defender and the question of how the detention would be justified related to the fundamental section of blah, 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 jurisprudence. Contrary to the Justice of the Peace conclusion that the applicant was not prepared to follow court orders and is prepared to do whatever she feels like during arrest, applicant had developed a track record with the surety, avoiding the breach of conditions that were imposed. There was no evidence of the any conduct that would arise and cause the breach of the public safety. Moreover, it also doesn't mess with the confidence of the judicial system. Whether she was with Marazzo or not doesn't matter. On the tertiary comments, there's no factual basis to assert that the contact with Mr. Marazzo could have posed any interference in the administration of justice. And now he's addressing the tertiary grounds. The justice of the peace focuses his analysis on the tertiary grounds, on the belief that the new evidence 17 was of some import. He accepted the Crown's submission regarding Mrs. Lich's leadership role with respect to item 17 in order to substantiate the strength of the Crown's case. The justice of the peace said, quote, in light of the so-called gravity also provided in the text message in item 17, Ms. Lich has revealed herself as one of the leaders of the trucker protest, and her inculpatory statements of not wanting to make a decision, of gridlock the nation's capital, unquote. While the justice of the peace is entitled to take the Crown's case at its highest, in my view, they overemphasize the import of line 17 because it did not justly show her to be a leader of the convoy by virtue of that message. Clearly, This is not new, late-breaking evidence to sustain the motion. The defense all but concedes that there was already ample evidence of a leadership role, which was considered and acknowledged by prior bail judges and reviewing courts. The judicial notice can be taken that 3 weeks, the streets of Ottawa were indeed in a state of gridlock. Indeed, we're acknowledging that the item 17 the justice of the peace appeared to overemphasize this piece of evidence. In fact, the text exchange in item 17 was repeatedly cited at least 11 times throughout the ruling. Yeah, you guys heard it yesterday. Significantly, the justice of the peace goes on to address Ms. Lich's potential lengthy term of imprisonment and some discussion about terminology. During his analysis, he determined that the applicant faced a potential imprisonment up to 10 years for the mischief-related offense, with a reference to a 3-year jail term to be served at section this. This relates to the potential sentence that the accused potentially faces. There's no strict rule regarding what constitutes a lengthy term of imprisonment, and the justice of the peace residing at the bail stage should resist the temptation to engage in a complex exercise in determining a sentence. Rather, the court must consider all the circumstances of the case known at the time of the bail hearing and reflect in general terms on the potential for a lengthy sentence. See St. Cloud, paragraph blah, blah, blah. In fairness, the justice of the peace is neither expected to know the intricacies of the sentence of the criminal code, nor the authorities surrounding the disposition of various defenses. I appreciate that Justice of the Peace Harris may not be legally trained or well-versed in the jurisprudence in indictable or hybrid offenses and cannot be held to the same standard of a judge in the court of law. However, given that the Lich, under the reasons of the tertiary grounds, it keeps cutting in and out, folks. It's all looking good, though. I mean, I don't know what to tell you. Yeah, so basically what he's saying, I'm going to give you my synopsis now because I'm still in the court, but I'm not hearing anything. basically yesterday they went through a whole case of trying to prove that she was a high likelihood to reoffend, that she was facing long time jail time, and made. Oh, I just did get kicked out. Whoa. Okay, let's do this again, folks. Hang on, hang on, hang on. Oh, here we go. Yeah, so the judge, this is looking very good for Tamara. I don't know. Hold on, we're going to do this again. We're going to do this again. Hi, folks. So if you're sharing this out, please put a title along with it, and that will help to get more traction so more people can see this. There is a media blackout on all of this. So the information that you're getting here, my interpretation of the information you're getting here is might be one of the only sources that you might be able to get it on. Okay, look at this. They did the same things they did yesterday. Hang on, folks. I'm going to